0000701 as well, Your Honor.
All right. And 2025-00701. Could I have parties announced?
Andrew Harrison with the state.
And this is Pauline Portillo along with Ms. Peyton Howe for Mr. Felipe Cernares.
All right. You all are scheduled for jury trial today. You filed a motion for continuance?
I did, Your Honor.
All right. And why?
We have several reasons. We do have a motion to inspect and examine evidence, which if granted, I think will require us some time to inspect and examine that physical evidence.
Why wasn't that done before today?
Because, Your Honor, through preparation with my client, which was very limited because of the time frame which we represented him, this was information I had to develop over the course of jail visits, which I couldn't get within 24 hours. And so through prepping with my client, we learned of some evidence that might be, and I would expect strongly, would be material and mitigating to the elements in the case. And so that's the reason why it wasn't filed earlier on in our representation of him, but it was filed before the jury trial date. I'll address that motion in a second. But the other issue is, Judge, we had requested missing discovery from the state. And since that request, we've gotten in about 12 videos that are pretty large. And even the state said it's a pretty big file that it took.
What missing discovery?
At this point, it's all been produced, but they are all recordings from SAPD personnel who are at the scene.
Okay.
And they're pretty large videos, Your Honor. And one of them, I think, includes the unmuted portion of the defendant's statements. And I also believe that that's going to have material and mitigating evidence for his defense. So it's really, really crucial for us to be able to review all.
All right, so review the video now.
Judge, these videos are an hour and a half.
Review the videos now.
The other issue with the motion for continuance, Judge, is that to prepare an adequate defense for him and to avoid issues of this case being appealed for ineffective assistance of counsel.
People love to throw around ineffective assistance of counsel. This case has previously been set. He had another attorney. It was set for jury trial, and your firm decided that you were going to represent him and get on a case knowing that it was set for trial. So if you all want to throw your swords on ineffective assistance of counsel and file that with the appellate court, that's completely up to you.
Next one, Your Honor. The issue is that it is very apparent to me that because there was so much missing discovery that was never requested, that there was not adequate prep work by the prior attorney. And that's why, unfortunately, and I don't want it to be held against them, it's taking us so long to put everything together and figure out the missing pieces.
Oh, no. Name the parties who you're saying didn't complete adequate discovery.
Name the parties that
who are you talking about?
The state.
Okay.
So the issue, Judge, is that I don't think that this should be held against him. He's facing substantial jail time. It's an enhanced first degree possession with intent to deliver. And so those cases, they require a lot of